Welcome, everybody. I am Eloise Scotford. I'm the Dean of the Faculty of Laws. It's my absolute pleasure to welcome you to UCL. Normally, I would be expecting to welcome you to Bentham House, which is the home of the Faculty of Laws, that is hosting tonight's event. But Richard's lecture was so popular, we had to relocate and move out of our home in Bentham House and move down to the Institute of Child Health. So I welcome you to UCL. It is such a pleasure to welcome Professor Richard Moorhead, who is the most wonderful former colleague. To welcome him back to UCL. We do miss him, but we really are delighted to share in honouring him this evening in giving tonight's Hamlyn lecture, the final in this series. It's also my pleasure to welcome the Hamlyn Trust, whose trustees do the most incredible job promoting and safeguarding a much treasured and very valuable aspect of the Legal Academy. I wanted to say something very briefly about the field that has spawned the content of tonight's lecture, which is, I think it's kind of a number of fields, subfields of legal study, legal ethics, the study of the legal profession, empirical legal studies. All of these things are at play in Richard's work, but in the lecture this evening. Surprisingly, I think, considering the size of this audience, and certainly frustratingly from my perspective, these are kind of more niche areas in the Legal Academy. But that does not say anything about their importance to the role of law in society, and it is, I think, fitting that it is being celebrated in the Hamlyn Lecture Series this year. But they're subjects that we at UCL Laws have been very proud to champion, support, and lead in the UK. So on behalf of the faculty, I'm absolutely delighted that we're hosting a lecture from such an eminent legal scholar addressing some of the most visibly pressing issues for lawyers today. Yes, in the UK, but I think beyond that. It is now my great pleasure to welcome Professor Edrom, who is going to speak on behalf of the Hamlyn Trust.
Thank you, Eloise, and thanks especially to you and to Laura Howells, the UCL Centre for Ethics and Law, and the UCL Law Faculty for hosting this evening, as well as the Hamlyn trustees for assisting with the reception. So what is Hamlyn then? Well, Miss Hamlyn, Emma Hamlyn, was the daughter of a solicitor in Torquay. And before she died, she decided she would write her own will. And this is what she wrote. Upon trust to apply the income of the trust fund in the furtherance by lectures or otherwise among the common people of this country of the knowledge of the comparative jurisprudence and the ethnology of the chief European countries, including our own, and the circumstances of the growth of such jurisprudence to the intent that the common people of our country may realise the privileges which in law and custom they enjoy in comparison with other European peoples, and realising and appreciating such privileges may recognise the responsibilities and obligations attaching to them. Well, it was of major interest to the law courts, and it did get through by 1949 when Lord Denning gave the first lecture on freedom under the law, and the level of lecturers has not dropped since. It's my job then to introduce you to the chair of this evening, Lord James Arbuthnot of Edrom, who, according to Burke's peerage, is a descendant of James V of Scotland, and was a Conservative MP from 1987 to 2011 after Trinity College, Cambridge and the Bar. But most important for tonight, he played a pivotal role in helping the sub-postmasters affected by the post office scandal to seek justice. He's one of the true heroes of this awful issue and has worked tirelessly for years on behalf of the postmasters and is now a member of the Horizon Compensation Advisory Board. If you don't recognise him, he was portrayed by Alex Jennings in Mr. Bates versus the Post Office, the TV dramatisation of the scandal. He's therefore the perfect person to act as chair of tonight's crucial lecture. Lord Arbuthnot.
Ladies and gentlemen, common people, actually, well, I am descended from James V. I wouldn't be at all surprised if most of you were as well. My name is James Arbuthnot. I first became involved in the post office scandal in 2009, so that was 15 years ago, and I can only apologize for taking so very long to get anywhere with it. But the size and the quality of this audience tells us that at last we are getting somewhere, thanks to many, many people, many of you in the audience tonight. One of those people is Richard Moorhead, Professor of Law and Professional Ethics at the University of Exeter. He is, like me, a member of the Horizon Compensation Advisory Board, advising the Department for Business and Trade. That came about because the Post Office Minister rang me up and said he wanted me to join an advisory board to advise him. I think I was going to be the only parliamentarian on a board of civil servants, and I said, that won't work. You need at least Kevin Jones, now Lord Beamish, as another MP, but also, I said, you need Richard Moorhead. The minister said, but hasn't he been critical of the government? Yes, he has, I said, but so have I. And so, actually, have you. Oh, well, fair enough, said the minister. And how right I was, because Richard has been at the centre of key advice that we've given to the government, and without him we might not have seen the overturning of hundreds and hundreds of convictions earlier this year. He qualified as a solicitor, but has spent over 30 years researching and teaching on lawyers. He is an honorary professor here at UCL, where he was the first professor of law and professional ethics until 5 years ago. He graduated from Warwick Law School the year before Jason Beer. Ladies and gentlemen, Richard Beer.
I ended the second Hamlyn lecture with a basic and practical question, which was, what do we need to do to promote more rigorous, honest, integrity and independence of judgment in the legal professions? And tonight I'm going to try to provide my own answer to that question. But first I want to say how great it is to be back at UCL Laws for the third of these lectures. I'm very grateful to all my former colleagues, especially Eloise Scotford, the Dean, Anna Donovan, who's the Director of the Centre for Ethics and Law, both of whom are hosting this evening's celebration, and Laura Howes from Events, who has been extremely professional in organising today and getting so many of you here. And I also want to mention my colleagues in the Post Office project, Sally, Karen, Rebecca and Paul. I draw on some of our work tonight, it isn't all my work, and also they have provided sterling support, moral and otherwise, over recent weeks. I really thank them because I have gone a little bit missing in action, it's fair to say. And I'm immensely grateful, of course, to the Hamlyn Trust and the trustees for this absolutely fabulous opportunity. I'm really most thankful. And of course, I want to pay tribute to all the sub-postmasters and sub-postmistresses who have been sharing their stories with us in the research and whose absolutely remarkable resilience in the face of exceptional adversity is an example to all of us. And of course, I want to dwell a little on my next thanks for a slightly mafioso funeral feel to the photo. You can see why they got me on the advisory board. James, we all know Lord Arbuthnot as and I mean this seriously, a hero of the post office tale. He is, it's a cliche, but it's also true, he is a national treasure. And having got to know him a bit, I am able to confirm he really is a marvellous man. It's not an act at all. But I want to make a slightly different point. You might think it's this. It's not that exactly. James is a politician, but I already believed that not all politicians are bad. Indeed, most, I would say actually, are selfless public servants doing their best. Now, James, of course, does his best rather better than most other people's, but even so, he's trying to do the right thing, which brings me on to lawyers. Not all lawyers are bad apples. And it's often suggested to me that, you know, Richard, not all lawyers are unethical, a point with which I heartily agree. But I would also reframe that. For the reasons I've given over the last 2 lectures, many lawyers are vulnerable to ethical failure. Difficult situations, complacent thinking, poor practices, and pressure can make fools of us all. And that's one reason why, across more than 20 years or so, the post office scandal has seen lawyers responsible for unfair contracts, aggressive enforcement and making examples of litigants, prosecutions with key evidence missing, and outrageous plea bargains. Improper influencing of experts, badly briefed or improperly briefed by the lawyers. Disclosure failures that range from the unreasonable to indefensible suppression of evidence. The exploitation of legal professional privilege. Flawed and conflicted so-called independent reviews. Second Sight's investigation undermined by deliberately aggressive, I would say, legal handling. Sanitising reporting to the board and beyond carried out by lawyers. Sorry, it's a long list. An attritional mediation scheme. And where we all started in a way, scorched earth, flat earth litigation in the Bates case, based partly on misleading evidence and arguments. There's the questionable recusal advice, and non-disclosures, the abuse of libel threats, and guilty pleas even used to silence people. And it's probably true to say claims of misconduct and covering up continue even to this day. Now, each of these points raises questions about the lawyers involved. Lawyers senior and junior, in-house and, really importantly, in private practice. General counsel and King's Counsel, even a senior retired judge is involved. All are linked by 2 things: working for the post office and thinking in a particular way like lawyers. Their failures or mistakes, depending on how we look at them, include questionable judgments, negligence, cynicism, recklessness, and even more deliberate wrongdoing. Many, but not all, I would say, may be professional misconduct. Some may even be criminal. But in tonight's lecture, I will look less at individuals and more at systems. This is not to excuse individual responsibility, but because we need to think more broadly than blame. We need to reduce innocent error and poor judgment, as well as misconduct. The behaviours and cultures need to change. We need to think, I would say, about whole systems. Now, I've suggested in the 2 earlier lectures that these failures and others like them are driven by human frailties and organisational cultures that reduce our capacity as lawyers for objectivity. They are also driven by shallow, inadequate professional scripts about what being a lawyer means, irresponsible orthodoxies, irresponsible practices. And mutual irresponsibility and zeal lead to the taking advantage of professional secrecy, legal professional privilege to us lawyers, and that drives partiality, half-truth, and the drowning out of honesty and integrity. And I've also suggested, and I think this is really important, that this is very much not just a post office problem. I've talked a bit about cases for banks and oligarchs and even threats to national security posed by professional enabling, alleged slaps, the abuse of non-disclosure agreements, and corruption and hacking. The Blood inquiry, Sir Brian Langstaff's inquiry, only contains a tiny little amount on lawyering, but cover-ups are a practice for which lawyers appear far too useful. Look at his definition: deliberate concealment, lack of candour, half-truths, the massaging of risk. It's almost the executive summary to Sir Win Williams' forthcoming report into the Post Office inquiry in a few words, I suspect. A whole system approach to the Post Office scandal would require us to think about a lot. We could talk about government policy pushing the Post Office to be more commercial and courts to be more managerial. We could talk about criminal justice policy or the design and resourcing of courts, systems for redressing inequality of arms, legal aid, cost recovery, litigation funding, and so on. But I concentrate tonight on lawyers because, well, we've only got an hour, but also because the evidence suggests lawyers were not merely advising in the Post Office, they were running the show. Lawyers drove the view prosecution was justified, and when challenged, lawyers drove the view that the prosecutions were safe. Lawyers stepped in more than once to say it would be unwise to investigate Horizon independently. Lawyers were crucially responsible for suppressing adverse evidence within the Post Office and shaping how that evidence was understood internally and externally. Lawyers, all of those steps. Early drivers for these positions came from the business, I would say, but by the time the scandal shifted, certainly from attack to containment, I would say the evidence suggests legal-led. The lawyers led. Even so, a systems approach reminds us of multiple influences. It's more complicated than that, if you like. There are different levels at work. If we think about where the facts about Horizon came from, for instance, witnesses running the Horizon system wanted to look competent and to help their employers, yeah? Perfectly natural. Lawyers glossed those stories in favourable terms in witness statements, and they engaged in so-called sophisticated evidence management. They built glosses to varnish, and they skirted and suppressed adverse evidence in the making of their case. A self-justificatory truth was created, our famous flat earth. And of course, story refinement is both natural and dangerous. It's part of a lawyer's job. It's part of an advocate's job. And those stories are interpreted by decision makers who react to their immediate pain points. They hear what they want to hear and are told sometimes what they want to be told. They let things slide that they should not or that they don't understand. The business always wants success, optimism, a way forward, and the story and the advice has to or tries to adapt to that need. Problems, which can be factually complex, involving many different bits of the business, are spread over a lengthy history. They become distorted. No one is responsible for that distortion or for the holes. Everyone has reasons for forgetting or not mentioning difficulties. It's always someone else's job to speak up if there are problems. So what organises this kind of system in practice? Such failures, systems theory tells us, are organised by the system's dynamics. And this should make us wonder, why is this system unbalanced? What's wrong with its identity, philosophy, and purpose? Viable systems, we're told, seek stability, not maximisation. They balance long-term and short-term interests. They don't allow one signal in the system to swamp all others. What we see in the Post Office scandal is information being processed on the basis of what is arguable or helpful rather than what is true, fair, and balanced. A culture of, if you like, can we get away with it, deliberately or accidentally is created, driven by wishful thinking and legitimised by lawyerly zeal. What is maximised is a self-serving version of the truth. And in aligning the interpretation of facts, law, and the design of strategy to the client's preferences, maximally, to the maximum, lawyers cease to maintain the integrity of their role. A lack of independence means the legal signal that a lawyer sends about facts or law into the system becomes something of a cipher for their own self-interest and the self-interest of those around them. This pressure on independence is an everyday phenomenon. The SRA's thematic review on in-house practice has shown this. But there are also signs it's true in private practice too. It's private practitioners who, in this story, have offered to turn our legal refuse into gold. They compete to say yes more. They compete to be more commercial, to be more business partnery. They suggest they might rather enjoy, one or two of them anyway, steamrolling our opponents for us. The desire to impress those we work with can also be stronger than the efforts and risks in resisting what they want to hear. It's difficult to say no, to resist. And the way that decisions are really taken makes this worse. So systems thinking and lots of psychology views decisions as relational, not rational, pragmatic, not analytical. Evidence and argument are often not weighted forensically in the way that we lawyers like to think we do things. Satisficing takes place. Decisions are goal-oriented. They're attempts to garner or show that we're in control. And they are taken, of course, under difficult conditions. Time-limited, uncertainty, high stakes, vague goals, and so on and so forth. Indeed, it's been said, we don't make decisions, we fight fires. We sense problems and we react to their shape and their heat rather than something deeper. Disclosure may be an example of these decision problems. Evidence to the inquiry suggests Post Office lawyers sold their goal as not disclosing harmful documents. Reasons were geared to finding a reason for refusing disclosure. A fair application of disclosure tests was inherently unlikely. Rationalization of unfairness was inherently likely. So, how can we change things? How do we change decisions and behavior? An interesting question is, can we, or how can we reorient decisions towards what the rules actually require, towards integrity, not self-interest? Now, a lawyer might say the rules of disclosure need changing, or investigation of failures by the regulators just needs to be improved. And a whole systems approach suggests such changes are unlikely to work alone. A behavioural approach is needed involving rules and processes that take better account of human interactions. Institutions, cultures and philosophies, how people will respond to attempts to change them, to reform them, need to be factored in. Because we are dealing with deep-rooted orthodoxies and a complex system, changing it will be very, very hard indeed. The desire to let the ripples of the Post Office scandal dissipate and the pond of law to return to normal will be very strong indeed. A concerted effort across years, not months, will be needed. Let's look, though, then at the first of these, enforcement and culture change. A typical response, as I've said, to a litany of failures that I've outlined is we just need to punish the bad apples more or more effectively. Now, rigorous investigation and firm but fair enforcement are essential to persuading the public to trust law and lawyers and the profession to take professional standards seriously at all times. The senior figures in this story, I would say, need particular scrutiny. And there is, it seems to me, a very plausible case that enforcement, if done well and as openly as possible, can significantly improve culture. But even if done perfectly, it alone is not going to be enough. Enforcement only touches cases investigated by the regulators. It's reactive, it's expensive, and it's vigorously resisted, especially by well-resourced lawyers and firms. It also shreds the nerves and lives of those involved, those complaining and those complained against. There is evidence, mainly anecdotal, but I would say of good quality, that SRA investigation is not done as well as it should be. While the That wasn't supposed to be a joke. Why? Oh gosh, just you wait. Okay, while the SRA has high success rates at the SDT, which it does, that suggests they are sometimes too cautious, tending to pick low-hanging fruit. They certainly, I would say, recruit investigators at levels unlikely to attract the calibre necessary to take on big firms well, for instance. For the Bar Standards Board, the situation is significantly worse. In particular, if you look at this report, Field Fisher, into the BSB's investigations, published, I think, earlier this year, that is highly critical of the BSB's investigations. This, plus the Legal Service Board's own assessments of regulatory performance, suggest wide and significant problems, I would suggest to you. Smarter, better resourced, more respected regulators, or I would argue a single regulator and possibly a single disciplinary tribunal, are probably essential elements of change. Let's look then at education. Now, of course, good qualification and ongoing education are essential. The regulators hope the SQE, Solicitors Qualifying Exam, and tougher bar practice course assessments have raised standards. Those claims can and should be tested, as we did in this work for the Inns of Court College of Advocacy a few years ago. They should be tested. Let's see how the standards are working out, if the training's working. And for somewhat understandable reasons, the regulators have largely surrendered their soft power over undergraduate education. Clinics aside, and you sort of heard this from Eloise earlier, clinics aside, courses and lawyers, and especially ethics, have always been niche. They've always been Cinderella subjects in UK law schools. Law school heads and law firms should be clamouring to change this. They should be looking for this from the people that they recruit. But it's also incredibly important for students of law, whatever their eventual career, to be taught to think critically and reflectively about lawyering. It's a central part of the system. It's part of the rule of law, what we do, how we do things. We should be teaching students to think properly about this. For practicing lawyers, some suggest compulsory annual refresher training on ethics. How to get learning on ethics taken seriously, especially in practice, in ways that change thinking and behaviours, which is what's important, is difficult. The speed and invisibility of investigation and enforcement does not help. Regulators could be more open. They could share better information. They could look for ways to spark more water-cooler debate. The regulators, who are often pretty ordinary producers of research, could agree to fund an independent centre of research and education to drive. I am actually being serious. I know I'm thinking of my retirement, but I think this is a really important idea. To drive educational infrastructure, which would help, for law schools set up courses, debate and insight. And whilst execution could be improved, I should pay tribute to the SRA's guidance, thematic reviews and warning notices in particular. I do think they have progressed debate. It would be nice to see some evidence of that, but I do think it improves practice. And of course, more robust enforcement might also drive an appetite for preventative training. Another route to progress, which I'm going to come back to, is to start engaging with and challenging what chambers, firms, teams, and especially COLPs, compliance officers in law firms, do to foster an ethical culture, but I'll come back to that, as I say. I should also say that this too is, or these are areas where the BSB is, I'm afraid, I would say rather less strong than the SRA. Let's talk a little bit about the courts. Okay, courts can influence ethics in all sorts of ways. Wasted costs, contempt applications, through disciplinary appeals. We could talk about a whole bunch of things. But some points on how courts contribute to the broader ethical climate, I think, are merited tonight. Individual judges send mixed signals on ethics. I would say they vary in their enthusiasm for zeal or restraint. Now, my instinct is this depends on the case before them, fair enough, varied grasps of regulatory law, kind of who can blame them, and divergent philosophies. John Sarabji, another prof at UCL here, has suggested that elements of civil justice reform have been resisted by what he calls judicial traditionalists and rejectionists. Similar ideological divisions may underlie judicial views on lawyers' conduct. There may, for instance, be something of a fetish made of the red-bloodedness of commercial litigation by some. When faced with questionable conduct, judges can be disinclined to get too involved for understandable reasons. They may talk equivocally sometimes about naughtiness by practitioners. Rough tactics in litigation is what I really mean. But they are also, of course, sometimes accused of going off half-cocked in contempt cases. Problems with things like witness statements give rise to a host of difficulties. Poor management of those may be one of the things that's contributed more generally to flat earth drafting in cases. It seems to me a thorough critical look at how judicial practice impacts litigation ethics would be both timely and helpful. Ongoing constructive challenge may be needed to consider how the messages judges send and the behaviours they sometimes tolerate align with ethics, justness, and professional codes, not to mention proportionality. Problems may not primarily be about rules, but also about power and culture. Now, one comment about Sir Peter Fraser's handling of the Post Office case stands out, and it's been made to me repeatedly by senior litigators, which is why I mention it. They say to me, I find this surprising, but this is what they say, many High Court judges would not have stood up to the Post Office team as robustly as Sir Peter did. Sir Peter's immense judgments, and I don't just mean they're long, because they are long, but they are immense in other ways, suggest they might be, in a number of important ways, true. One can easily imagine a different judge taking a far less robust line on the behaviour in Bates. They might make some gentle remarks about polishing evidence or the perils of witnesses in complex cases and skirt round the issues more directly related to the lawyering. That the Post Office legal team tried to pressure the judge in a number of ways also tells us they thought it a tactic worth trying. Judges are independent, of course, fiercely so, but they're also conscious of their reputations. There were costs and reputational risks in Sir Peter making such a powerful and prescient stand. The arguments made in and around the attempts to recuse him, if you follow that, show this actually in spades, I would say. Another way of putting this particular point is that big beasts, and I'm thinking about firms in particular, appear to have more institutional power than courts, or certainly individual judges and regulators, over the culture of litigation. They can fight the long game through appeals and in any subsequent regulatory investigation as repeat players. Judges are exceptional of intellect and independence, but they also work alone, practically unsupported. Better resourcing and support for judges is both unlikely and, but I have to say it, essential to the management of cases with difficult parties and lawyers, and indeed beyond that, essential to it. I don't see how they can do their job properly without this. And however it's done, there needs to be a concerted, ongoing, visible effort for regulators and judges to work together on cultural problems in litigation, and indeed costs and, everything else. Okay, a new topic. Can we change the rules around legal risk, the risk calculus, as I call it here? If lawyers are too zealous, too inclined to abuse arguability and fact management, as I hope I've shown you over the last 2 and a bit lectures, can we simply change their rules of engagement? Rather than allow any merely arguable point to be taken, could a higher threshold be demanded? Could the rules require arguments to be closer to well-founded and reasonable, rather than merely arguable? Could this be done in court proceedings? Should lawyers even be required to operate under a duty of an obligation of candour? For reasons I'll explain, I'm not sure. But interestingly, candour is required in some cases, and recent research at the University of York suggests it works reasonably well in judicial review. Requiring reasonableness of interpretation outside of the courtroom, I would say, is even more strongly indicated. When providing formal opinions or ordinary advice to clients, the law gives a gentle nudge in that direction, and I think that push could be made much more firmly by the courts and by the regulators. And we know that advice seeking can be done in ways that are manipulated by clients, although sometimes professional failure to resist foreseeable or actual manipulation may also be an issue. Now, I said I was not sure about intervening in this kind of minute kind of rule because the minutiae of such judgments make enforcing different rules, different risk rules, difficult, and certain cases merit a more flexible approach. Criminal defence is an obvious example. Law sometimes, in fact often, are protean. They are genuinely uncertain. Judging after the event, a lawyer's application of uncertain law and their application of messy facts on the ground is difficult. It might boil down to whether a higher test than properly arguable is easier to define than police, and I don't know if it is or not. Requiring arguments to be supported by sufficient evidence in the relevant context or guarding against the exploitation of advice may work better in this kind of context. But there's another, more flexible, system-sensitive approach which might be more effective and perhaps a little bit less intrusive in a way. And I call this these accountability solutions. Let me try and illustrate what I mean with another example. This is an example of a lawyer doing the right thing. That's a bit unusual in these lectures. Jordan Breslow was a general counsel in the US. Breslow's CEO, his boss, asked if they should offer new employees a particular kind of stock option clause, a share, give them some shares in the business. It was an incentive for them to join the company. The clause enabled a particularly favourable valuation of the option. It made it a particularly good deal for the employee. It was a great deal for them. And the company's competitors were offering these deals, and that was making their competitors a more attractive place to go and work. So they really wanted these stock options. But something bothered Mr. Breslow, and he took some time to think about it, to research it, and to talk it through with others. And here's how he described it in this interview on the Crafty Counsel site. It's worth a listen. Other people, he said, were doing it. The advice from outside law firms was there's nothing strictly illegal about that, and he thought that might well be correct, technically, but he realised illegality can come from the fact that you might fail to disclose and account for this practice properly. And all in all, it seemed too good to be true, and so I said to Ben, the CEO, I said, it didn't make sense to me, I didn't think it was strictly legal, and I didn't want to mess with it. And they didn't. And that was a good call. Such deals were subsequently investigated and prosecuted. They led to jail sentences, including for the chief financial officer that had recommended it to Mr. Breslow's boss. She went to jail. Building a relationship of trust like this is complicated, but Breslow and a substantial number of GCs I speak to suggest some basics. They say the GC should always report to the CEO. Breslow, this is often the case, but not often, not in a majority of cases, I would say. Breslow describes reporting indirectly as self-evidently wrong. He says there's a necessary tension with the numbers guys. CFOs, he says, tend to be strong, creative people. GCOs, he means, yes, creative in that sense. GCOs are there to keep them honest. You keep people from acting on their own worst impulses, he said. Now, Breslow was not your typical risk-averse lawyer. He was just not risk-maximising. He was willing to be aggressive and creative in certain situations. But he also had a let's not do anything illegal philosophy. He had it and he meant it, I think, is what he really means. And he also said, this is important, he never felt unsafe. Saying no to them, the clients, or making a recommendation that they might not want to hear was not a problem. They were up for it. In other words, philosophy and psychological safety are important. His model also depends on trust and authenticity, on the good faith handling of legal risk. Independence, to a degree at least, then coexists with interdependence. Now, a rule cannot magic up that kind of relationship, but certain kinds of rules may make it more likely. How? Well, there's evidence that in positions of responsibility, where they are accountable for those responsibilities, lawyers actually improve the management of legal risk. They reduce it. Lawyers hired onto boards or senior exec roles substantially reduce legal breaches. Good evidence from the States. Illegality also decreases where lawyers have a signing off function, personal responsibility, exposure to liability, or particular reporting requirements around legal risk. They all work. They reduce excessive legal risk taking. Other things weaken these effects. I put these in for interest. Aligning lawyers' bonuses with business performance, surprise, surprise, increases legal risk. A poor relationship with the CEO increases legal risk. And my personal favourite, for certain matters at least, the retention of top-tier outside lawyers, I mention no names, increases legal risk. Now, a worry might be, in the States, I should say, a worry might be that accountability mechanisms drive excessive risk aversion, but the evidence does not suggest that either. So one study found, for instance, GCs appear to tolerate moderately aggressive behaviour, but constrain it when it would result in violations of security laws, for instance. So it's only when people really go to beyond that point of towards serious illegality do they step in. Now, accountability mechanisms are also central to the senior managers and certification regime in financial services. And evaluation of these reforms is, I think it's fair to say, thin on the ground, at least empirical evaluation. But I am told regularly, it's volunteered to me, I don't ask, especially by lawyers in financial services, that this has had a significant beneficial influence on the culture around legal work and indeed in those organisations more generally, whistleblowing, for instance. For that reason, I would suggest a particular focus of reform on building and strengthening accountability systems for legal risk in organisations, companies and the like, and in the professions. In broad terms, accountability systems need to ensure named individuals are responsible for managing and taking legal risk decisions and that they can be held accountable for them, that they're likely to be held accountable for them. I would suggest that such people may need to be identified for legal risk management generally in organisations and perhaps specifically for certain big projects like big litigation. So a company should have a named individual taking responsibility for the oversight of legal risk, with default rules for when that's not done. And in the financial services sector, this role should be mandated under the senior managers and certification regime. And something a bit like this was talked about in the recent IOD report, which I helped a little bit with. Corporate governance guidance should also encourage good practice on legal risk management, more generally, ensuring and supporting the ultimate responsibility of the lead and the board as appropriate. Board effectiveness reviews should actively consider legal risk management. They don't seem to do that currently, at least not normally. And such guidance should cover appropriate lines of management, so who manages the General Counsel, for instance, and channels of communication between the business and its legal advisors. Guidance and lawyers' contracts should include legal advisors inside and outside the organisation being able to access senior decision makers when matters of serious concern arise on the things that they're working on. Professional regulation and guidance should aim to mirror these sorts of requirements. Now, a problem is regulators do not have the power to regulate in-house lawyers unless they happen to be one of their kind, solicitors or barristers in particular. But they could do more to strengthen leadership and responsibility in teams through supervision requirements, for instance. And the SRA, after much urging, I should say, have begun to define independence and work in similar areas. The power of regulators to regulate in-house lawyers and support their independence more broadly is a technical legal problem. And I can think of various ways of solving it. They don't have the power at the moment, so some might involve legislation. But one thing that might give the regulators sufficient leverage to make a real difference would be to make providing legally privileged advice a reserved matter. If legal advice is to be legally privileged, maybe it should be reserved and therefore require a practicing certificate. Better accountability mechanisms might be particularly important for lawyers and parties threatening or bringing litigation. An interesting suggestion made to me is that there may be a case for firmer regulation of litigation in particular, to up what's required for litigators. And disclosure in particular might be an area needing attention. Something like a separate disclosure officer, as is best practice in prosecutions for civil cases, and documented responsibility sign-off around privilege disclosure and redaction of documents might be an idea worth considering, don't know. The extent and nature of disclosure failures in the Post Office scandal also render it tempting to recommend disclosure problems be made subject to a failure to prevent obligation, including responsibility for the proper management of legal privilege. Now, there would obviously be debates to be had about practicality, proportionality, and effectiveness, but accountability mechanisms are one of the few things that have been shown to work in restraining serious excess in risk-taking. COBs are another area, but I'm going to come back to those. I keep saying that, don't I? Okay. A change of pace. Can we challenge the philosophies of a certain section of the profession? Now, Breslow's story was about relationships, but it was also about philosophy. Can we change a section of the profession's philosophy? Can better models of ethics contest cynicism, expedience, or sophistry? How do we encourage and emphasize, rather than undermine, integrity and legality? You'll have heard me argue, if you'd followed the lectures, that zeal crowds out the true fundamentals of the legal profession: justice, honesty, and integrity. I think we need an approach that makes these public interest elements more lucid, clearer, and brighter. Integrity needs to be strongly and clearly present in the early moments of a lawyer's problem solving, front and centre, not back of mind. And I emphasise this lucidity for practical, not theoretical reasons. A lucid ethic should provide early warning signs to think carefully and guide actions. Now, my thoughts on this tonight are preliminary because our Post Office project team are researching how to try and evolve a more practical ethics of this kind. And we are working with lawyers on causal maps of ethical situations and how lawyers handle moments of challenge. If you're interested in that work and you're a lawyer, please get in touch. We'd love to involve you. Stephen Mason's work on public interest and Stephen Vaughan's on integrity provide very rich food for thought too on this. I would say that there are two aspects. One is interpreting law and certain law in good faith, respecting legality, counselling towards, not away from, what the law requires. But I'm going to concentrate on a second overlapping issue, integrity with facts and processes and so on and so forth, with honesty, ethics, and the rule of law, because my instinct is get integrity right and much, if not all, falls into place. And as Professor Vaughan emphasises, integrity underlines values already in professional law. So the great Sir Tom Bingham, when he was Master of the Rolls, reminded solicitors not to show anything less than complete integrity, probity, and trustworthiness, or expect severe sanctions. Sir Rupert Jackson more recently said integrity demands more than mere honesty. It involves taking particular care not to mislead and being scrupulous about accuracy. The emphasis is important, I think: scrupulousness, complete honesty, and particular care. I would add that the importance of integrity being judged in context alongside the reasonably foreseeable consequences of one's actions is really important too. I cannot simply advise my client, or I should not advise my client, reckless as to whether they will use my advice to mislead others, for instance. Expedience and zeal, though, encourage lawyers to narrow their focus, to frame facts and laws opportunistically, to search for an excuse for doing that which the law in spirit and not uncommonly in reality prohibits. It is not enough to think I have an argument for saying that is not misleading. My obligation, the particular scrupulous active obligation, is on me not to mislead anyone or to be even complicit in misleading anyone in the context I am operating in. It involves me considering the purpose, I would say, to which my work will be put. If we look back at Breslow's success, it's marked by stepping away from a narrow frame to a broad frame, from the stock option not being clearly illegal, as the private practice lawyers put it, to can I honestly account for it or not? Something similar is true of the interpretation of law. My interpretation may, of course, explore uncertainty, but it should also express legality. And if done in good faith, uncertainty and the risks of illegality that flow from them must be analysed and described as impartially and openly as possible, attending to the context. If a firm is asked for an opinion that will foreseeably assist illegality or mislead others, they should decline or take reasonable steps to prevent or limit that risk. James Eadie did the latter when advising on the lawfulness of the Northern Irish Protocol Bill, for example. He did the right thing. Lawyers should not, for example, design a system weakening sanctions controls and advise it is reasonable when they have clear advice that says it's unlawful. Rather than illusions of reasonableness disguising or excusing or distracting from illegality, they need to show complete integrity in that context. They should counsel towards, not away from legality. Now, lawyers may need to be encouraged to think contextually by better scaffolding. Drawing on Solicitor's Disciplinary Tribunal dicta, although supported in the High Court in the case of Sims, the SRA have said recently, a solicitor must sometimes say, it may be lawful for you to do X, but I will nonetheless not do it. They've been coy about what they actually mean about this, though. They haven't explained it. Sims is, I would say, a consequential liability type situation. Setting out all the consequential liability risks on lawyers when dealing with questionable projects would be one way of starting to flesh out what potentially lawful things solicitors should not do under Sims. The NDA debate has been rendered much more real, I would say, by recognising that how lawyers draft NDAs, not whether they draft NDAs, but how they draft NDAs, can amount to perverting the course of justice. And recent stories about Mohammed Al-Fayed show us an obvious but ignored risk about NDAs and potential witnesses in civil cases being prejudiced. It's another area, I'm afraid, where the Bar Standards Board have done, I would say, less well than the SRA. There may be various ways that integrity can be brought further to the front, rendered more lucid, more practically tractable. Scrupulousness, completeness, particular care to mislead, and responsibility of purpose should inform the aesthetic. They should feature more prominently in any professional code. And this brings me to some words that should be diminished in the professional's ethical ideology. To aid lucid ethical thinking, we should mute two related ideas: fearlessness and the presumption that lawyers can harm third parties for their clients. They should be removed from the codes and guidance. They romanticize aggression and they risk normalizing what is a much more complex situation legally around harm. Now, harm cannot always be avoided, but being required to consider and, if proportionate, mitigate or alleviate such harm might reduce some of the unnecessary excess, and I think the code should reflect that. There's a third piece of ground clearing to ensure integrity is central. I would challenge the claim that lawyers do law, but they don't do morality. I'm not arguing that morality should generally trump legal rights, but there is a great deal of hypocrisy in lawyers saying they do not do morality. They do it all the time. The disclaiming of morality often merely makes room for a morality defined by clients' self-interest. Banks thought evading money laundering controls are okay because the effing Americans were engaged in regulatory imperialism. They're up to no good, so we can get up to no good. The post office's obscene behaviour was dignified as protecting pensioners and public money against what people who they regarded as thieves and liars. We're up against them, so we can be more aggressive. From time to time, a show is made also of excluding morality from legal reasoning. Lord Sumption said, commercial parties can be most unfair and entirely unreasonable if they can get away with it. It's leadership for you. Sumption's cynical logic does not make ignoring morality good legal risk management. Do something entirely unreasonable, and it's likely to inspire opponents, regulators, politicians, and the press to take our clients on and ourselves on. They will publicise our amorality and seek out our legal mistakes. Many of the cases I've covered contain just such legal mistakes. Moreover, a sophisticated body of literature points to legal reasoning having an inherently moral component, especially in difficult cases. Indeed, judges draw on morals when deciding hard cases. Such lofty reasoning is not confined, though, to judges or jurisprudents. Breslow's initial instinct, remember, was to pick up on discomfort, not on illegality. Laws also replete with moral tests, dishonesty, reasonableness, iniquity, and contrary to what we might expect, used wisely, such tests can improve legal certainty, not reduce it. Anyone who thinks that rules and their amoral application lead to greater certainty and justice should read the contract arguments advanced for saying Harvey Weinstein's NDA was perfectly proper. They are jaw-droppingly awful. Rules, especially complex rules, unmoored from any notion of morality, I would say, beget manipulation. There's a final reason I would give for saying lucidity requires morality. It's probably the best for arguing that lawyers should be responsive to moral concerns, but not necessarily subservient to them. And that reason is cognitive. It helps them take better decisions. Legal problems are complex and social, littered with bias, partial-sightedness, and so on. The wise advisor knows they need all their cognitive faculties to do a good job. Their decisions require breadth of vision and moral sensitivity, not just narrow lawyer's logic. Now, I want to go on and on and on, but I won't. There's a great deal of detailed work needed to develop and improve guidance, to understand, define, and support independence, for instance, as a behavior, not just as an idea or a label, to work on lawyers reporting up and lawyers reporting out as whistleblowers, to work on the abuse of legal professional privilege and on the drafting of unreasonable contracts. The bar in particular, for a bunch of reasons, needs to revise its code of conduct. And I would argue lawyers should have a single, unified code of conduct. But I want to return to one more systems-oriented point and deal with a problem that has bothered me, fascinated me a great deal since I began watching the inquiry. It's got a fancy name. It's called the self-concept. The post-office inquiry has been fascinating for the occasional catalytic importance of independent challenge and accountability. Cross-examination, some of it fantastic, has shown how revealing, but also how hard it is to break through lawyers' defences against such challenge. We all resist the idea that we are bad, especially, it turns out, when being live-streamed on YouTube. As lawyers, we have our self-concept. We think we're better. We have the creativity of argument to justify our own and our clients' actions and to shape how we portray facts. And this means we can also delude ourselves. We're also more insensitive to our own rules than we should be. When we did research on barristers within 3 years of call, we found over 40% didn't know or could not properly use their own rules. These are practicing barristers. Yet sometimes, under very detailed questioning, the lawyers before the inquiries did, I think, realise their limitations and mistakes. And very occasionally, sometimes quite subtly, sometimes more explicitly, they conceded them. Warwick Tatford is perhaps the best example. It's actually quite moving if you go and watch it. The barrister alleged to have hardened up expert evidence when prosecuting Seema Misra. He painfully admitted, after a devastating cross-examination, that there are many failings that I had ignored on my part, and I perhaps created a rosier version of himself in my memory that wasn't really there. Professionalism is an idea that isn't really, or at least is not always there when it should be. It gets lost in the melee of winning cases. And I call this the professional imaginarium. We imagine ourselves as more proper, more competent, and more ethical than we are. Now, in spite of the imaginarium, the SRA found that 10% of in-house lawyers had said their regulatory obligations had been compromised trying to meet organisational priorities. They'd been forced to break their rules, is the basic lesson there. Now, 10% is, I think, a concerning figure in itself. But it also leaves me wondering, what about the 90%? Did they understand? And we have a clue about that from the 40% of barristers who were shaky on their own rules. We have no reason to think the solicitors are any better, right? Now, these two figures are rough estimates at best, of course, but they provide an important indication of the scale of the problem. So how do we overcome this weakness? How do we build greater self-awareness and improvement? We need to find somehow additional mechanisms short of investigation for encouraging accountability and self-development. Ethical practice should, of course, be routine, and ethical practice should, of course, be a routine and proactive part of competence review for all lawyers, wherever they may practice. There may also be situations where cases or areas of work of particular providers could be referred for non-disciplinary investigation and analysis by third parties to encourage lesson learning and remediation, not punishment. Now, the FCA, Financial Conduct Authority, has skilled persons reports. They appoint a skilled, independent person to require a report and remedial steps on a particular theme in a regulated firm. If the regulators do not have this power, and it's debatable, perhaps they ought to be given it so that they can do this. It's a useful tool. Imagine being able to ask Firm X to commission a review on its use of without prejudice letters, or Firm Y its management of litigation holds, or Firms ABC about the due diligence they do before sending out slap-like threats. The COLPS role, I would say, is underdeveloped, and the quality of COLPS and the COLP-SRA relations is, I would say, mixed. We also know relatively little about the effectiveness of this tool. There's been some work, but not a great deal. These are areas which need review and improvement to make the role effective. The regulators could also look to something similar to board effectiveness reviews. So boards call in third parties to review the culture of the board and the organisation, in essence. They do it regularly. So these reviews could be directed to look at how firms manage ethical culture. Reviews could drive improvement in the management of ethical culture by looking at COLPS and firm practices in particular. Now, care and time would be needed to develop reviews sufficiently independent, useful, and not tick-boxy in approach. It could mix voluntary approaches and targeted compulsion, for instance, at higher-risk firms or practice areas. The aim would be to develop in lawyers and their firms substantial and meaningful engagement with ethics and ethical leadership, a tool of kind of required self-improvement in a way. The challenge of encouraging authentic engagement and improvement should not, of course, be underestimated. Regulators and the regulated need to build mutual respect. They need to justify trust and respect in each other, and they both need to do that. Current approaches alone are, though, I would say, not enough. I've set out concerns about mutual irresponsibility and excessive zeal, but the eagle-eyed will have noticed I've not engaged that much with the third limb of the system problem, professional secrecy, legal privilege. Professional privilege is beloved of lawyers, and it's a fundamental right according to the courts. It is also unarguably abused, and it diminishes proper professional accountability. Now, it's an emotive topic for lawyers, and it's a very complex area, and I don't want to make precipitous proposals on the subject tonight. The regulators and the courts, though, I think, plainly need to grasp the nettle of abuse. And I would recommend, too, a full, independent review of the law on privilege. It's time, it's necessary. You'll be delighted to hear the next words. To conclude, the Post Office scandal is a lesson in how lawyers played, not just with facts and rules. They played with lives. They ruined lives. It's worse than that, though. They often led that harm. Incompetence and orthodoxy, cynicism and recklessness, complacency, vanity, and I'm sorry to say, sometimes dishonesty, played their part. The Post Office scandal shows us the lawyers have to do more than say sorry, half-heartedly or otherwise, and be disciplined by stronger regulators. we absolutely have to change the way lawyers think and behave. We have to put complete integrity and particular care not to mislead at the front of our thinking. We should turn away from lauding amorality and guard against harm. Lucid ethical thinking could be aided by modest changes to the codes, better guidance, and a concerted programme of work scaffolding that with training and guidance and explicit accountabilities and early challenge mechanisms. This may require modest changes in the law and codes and more fundamental development of the regulatory apparatus. It certainly would also require looking at corporate governance. Now, at first reading, to harried practitioners and judges, I understand it will sound like a forbidding agenda. And ideologically, these groups are not aligned. Many will be opposed, and resources are thin on the ground. It will require exceptional leadership and determination. It is for that reason I end with my final proposal. The Clementi reforms concentrated on competition and consumerism. It made significant progress, but it left ethics underplayed in the equation. It provided a compromised form of independent regulation. The post office scandal suggests unfinished business that requires something of similar weight, independence, and political commitment behind it. It needs to tackle issues in the profession, in the courts, and corporate governance, with its central agenda how to improve honesty, integrity, and effectiveness in the use of law. It needs to lead independent of, but also working with, government, the professions, the courts, and regulators. Given problems in accountancy, it may even need to encompass other professional advisors. I've set out tonight some ideas as starting points, but I suggest a strongly led commission with a mandate to address a programme of reform, not just one big bang. The victims of the post office scandal do not just deserve more sincere apologies and proper compensation, please God soon on that. They deserve real change in the integrity of lawyers, the legal system, and those who use them. That means real change properly implemented. It means much more and is much harder than mere words of the kind I've offered up tonight. Thank you.
I said right at the beginning that the quality... Where the hell are we going with this? The size and the quality of the audience established that we were getting somewhere, and those questions were proof, if anything, that the work that you have been doing, Richard, has been quite outstanding. Thank you for a fantastic lecture. But more to the point, perhaps, thank you for upholding the idea that this country is a country of ethics and fairness, and you are a shining beacon in that. So let's say once more, finally, to Richard, thank you very much indeed.